the court. Don't address to.
I'm sorry.
Yes, yes.
No, he is not there in that 4 writ petition list. My friend is not thinking that I am addressing it to him.
If your friend is incorrect, during your argument, you inform us. Don't, yes.
So, my lord, in 4 writ petitions, that is, my lord, WP 23775 of 24, 28488 of 24, and party in person 23907 of 24, and my lord, AOR Mr. Kaushik 28576 of 24. In all these 4 matters, 28576 of 24.
Geo 96 is not challenged.
Not challenged but not argued.
Yes.
Though, my lord, Mr. Madan Mohan Rao spent more time than Mr. Sudhir, but both of them, my lord, devoted about 5 to 10% of their arguing time for 96. My lord, 96 is what, my lord, brings the jurisdictional facts before this court. And I will also demonstrate, my lord, as to in what context the 96 had to be issued. My lord, we'll go there a little bit later. But, my lord, my reciprocal submission is that when the very maintainability of the writ petition before a division bench of this court, my lord, is available only if there is a challenge to a rule, because 29 alone, my lord, would have taken it before the learned single judge. I am not saying they should argue there, they should argue here, but kindly see the modus operandi to
Rule is under challenge.
Rule is under challenge, but my lord, how can a rule be challenged and not argued and something else argued and my lord, left it at that?
Somebody challenged the rule and argued also.
It is no, that is what I am saying. So, except Mr. Madan Mohan Rao and Mr. Sudhir, none of the counsel have argued, my lord, the challenge to the rule. On what basis?
We will not decide on the majority
I need to bring your lordship's notice.
If even a single person challenge the
Yes,
rule,
yes.
all linked matters will be heard.
In fact, my lord, if I recall, my lord, correctly what your lordship asked at the interlocutory stage, as to show us as to how did you lay the foundation for challenge to the rule, number 1. And the important aspect is none of the petitioners are physically disabled. And how come they are interested in challenging, my lord, the reservation which is provided for them? This is what, my lord, was the question posed. But, my lord, the fact of the matter is that 96 was not argued. I will show, my lord, how it has a bearing on the whole thing. My lord, I understand it is under challenge. Your lordship will have to deal with the pleadings. My lord, in this situation, now kindly see, my lord, the judgments that are relied upon. Firstly, my lord, the inspiration appears to be from, my lord, your lordship may take up the compilation given by Mr. Sodhi, my lord. On 312, అదే కోర్టు ఇచ్చారు. My lord, the inspiration, though appears to be the prayer, my lord, they say Deependra Yadav. Inspiration appears to be Kishore Chaudhary. This is, my lord, my understanding of the matter. So, my lord, my endeavor before your lordships would be to persuade your lordships to hold that neither of 2 judgments, my lord, have any relevance whatsoever to the current matter. Firstly, my lord, kindly take up Kishore Chaudhary, which commences at page 24. A judgment of the Divisional Bench of the Madhya Pradesh High Court, page 24, my lord.
Yes.
May I invite your lordship's kind attention to page 27, paragraph 2. Kishore Chaudhary was not under, my lord, consideration in Deependra Yadav. Your lordship has seen that. A subsequent judgment, my lord, was under challenge. Page 27, my lord, firstly para 1, my lord. Few writ petitions of this batch of 49 petitions are filed, assailing constitutionality of subsection 4 of section 4 of Madhya Pradesh Lok Seva अनुसूचित जातियों, अनुसूचित जनजातियों और अन्य पिछड़े वर्गों के लिए आरक्षण अधिनियम 1994. Whereas rest of them are filed with a prayer to declare Rule 4.3d Roman 3 of Amendment dated 17 February 2020 in Madhya Pradesh State Service Examination Rules 2015 as ultra vires. The admitted facts between the parties are that the Madhya Pradesh Public Service Commission published an advertisement on 14/11/2019 for conducting state service examination 2019 for a total 571 posts, including the post for reserved category. In furtherance thereof, the petitioners submitted their candidature in prescribed form for appearing in the said examination. On 12/1/2020, preliminary examination was conducted by PSC. Soon thereafter, the impugned amendment in the rules came up into being by publishing it in official gazette on 17/2/2020. The result of the said examination was declared on 21/12/2020 on the basis of amended rules of 2020. Aggrieved, these batch of writ petitions were filed. In these petitions, the respondents were put to notice and in turn they filed reply. After receiving notices in the petitions, yet another amendment dated 20/12/2021 was published in the official gazette on 20/12/2021 amending the said examination rules. On 31/12/2021, the PSC declared the result of the said examination and proceeded further to take interview of the candidates. My lord, these are the facts, my lord, under which this matter arose. My lord, what comes out of this is firstly, the preliminary examination was held in terms of the unamended rule. After the conduct of the examination, the rules were amended. After the filing of the writ petition, the amended rules were once again amended. My lord, this situation in my respectful submission does not arise before your lordships. It is, my lord, I can see it is far more complicated than what is there before your lordships because three mains examinations were conducted, my lord, in Madhya Pradesh. In pursuance to the amended rules, unamended rules, and my lord, the normalization aspect was gone into by the Supreme Court in Deependra Yadav. The committee was, my lord, called to explain, and the Supreme Court was satisfied with the process of normalization. My respectful submission before your lordships is that there is no rule whatsoever, neither 96 nor 29, have been issued after the prelims was conducted. And there is no question, my lord, of any change in the rules of the game once the game has commenced. Therefore, my lord, in my respectful submission, Kishore Chaudhary facts are entirely different. Now, kindly see, my lord, as to whether those rules, my lord, are also anywhere, my lord, in anywhere near to 29. Kindly see page 29, paragraph 8. It is common ground taken by all the petitioners that the selection process started with issuance of advertisement on 14/11/2019. As per the rules prevailing at that point of time, the respondents were obliged to treat the reserve category candidates who have secured marks equal or more to a UR candidate as UR candidate at all stages, including preliminary and main examination. This procedure laid down in the main rules could not have been changed to the detriment of petitioners after game was started. In nutshell, it is argued that rules of game cannot be permitted to be changed after commencement of game. This is what, my lord, I had submitted before your lordships. Then, my lord, Saurav Yadav is relied upon at paragraph 17 at page 31. While extracting the contentions of the petitioners, because they are relying upon Saurav Yadav, I am bringing this to your lordship's notice. Now, kindly see the findings of the divisional bench at page 32, paragraph 25. Yes. Constitutionality of section 4(4) of the Adhiniyam. Kindly see, my lord, what is the rule that is challenged? The petitioners have raised eyebrows on the expression "get selected" used in this provision. Section 4(4) reads as under: if a person belonging to any of the categories mentioned in subsection 2 gets selected on the basis of merit in an open competition with general candidates, he shall not be adjusted against the vacancies reserved for such category under subsection 2. My lord, this is what is there. Now kindly see para 26, my lord. A division bench of this court in the case of Srimati Rajshri Tiwari versus State of Madhya Pradesh opined that subsection 4 of section 4 of the Adhiniyam of 1994 is in consonance with the interpretation of section 16(4) of the Constitution given by the Supreme Court in the case of Indrashoni. In this backdrop, we are unable to declare subsection 4 of section 4 as unconstitutional. My lord, this is the finding of the division bench with respect to 4(4) which is extracted in para 25. Now, my lord, kindly see what is the import of GO25, my lord. I'll have to pause here, my lord. It is necessary to see what 29 says and what does the amendment say. Before that, may I invite the lordship's kind attention to 55 first at page 168 of the writ petition compilation.
One
168, my lord.
Yes.
Kindly come to, this is where 55 is placed. Kindly come to page 171, my lord. Capital paragraph B.
Yes.
The number of candidates to be admitted to the written examination would be 50 times to the total number of vacancies available in each multi-zone, duly following the reservation for community, gender, EWS, physically handicapped and sports, as laid down in General Rules 22 and 22A of TS State and Subordinate Service Rules. This is what, my lord, 55 said. Now kindly see what 29 says, how it amends paragraph B at page 178, 10 pages later, my lord.
Yes.
178 bottom. The number of candidates to be admitted to written examination would be 50 times to the total number of vacancies available in each multi-zone, provided that, my lord, this proviso is created by 29, provided that in case of any shortfall in respect of candidates in reserved categories as laid down in Rules 22 and 22A of Telangana State and Subordinate Service Rules 1996, action shall be taken to include such number of candidates from the merit list beyond 1:50 ratio as required to meet the shortfall in the respective categories. This, my lord, is challenged before your lordships. My lord, this is nowhere near to section, my lord, 4.4 of the Adhiniyam 1994, firstly. Because, my lord, there is a specific provision as to how to deal with that situation. Now, it is also required, my lord, since both 55 and 29 also speak about 22 and 22A. Now, let us see whether 22 also, my lord, is anywhere near 4.4 of the Adhiniyam. Now, you would watch this kind attention to the State and Subordinate Service Rules. Books time. Kindly go to page 37 of the booklet, madam.
Yes.
22.1. The reservations may be made for appointments to a service, class or category in favor of scheduled castes, scheduled tribes, socially and educationally backward classes, women, persons with disability, meritorious sports person, ex-servicemen, and such other categories as may be prescribed by the government from time to time to the extent and in the manner specified hereinafter in these rules or as the case may be in the special rules. The principle of reservation as hereinafter provided shall apply to all appointments to a service, class or category. Then 222(1) small Roman 1. By direct recruitment except where the government by general or special order made in this behalf exempt such service, class or category. Then, my lord, otherwise we are not concerned. Then, my lord, 22(2)(a)(1). The unit of appointment for the purpose of direct recruitment shall be 100 vacancies, of which 15 shall be reserved for scheduled caste, 6 shall be reserved for scheduled tribes, 29 shall be reserved for socially and educationally backward classes, and remaining 50 appointments shall be made on the basis of open competition and subject to Rule 22A of these rules. Then, my lord, 22(2)(a)(2) deals with promotion. We are not concerned. Rest of the rule, my lord, perhaps may not be relevant for the present inquiry. My lord, 22(2)(a)(1) clearly shows the manner in which the reservation has to be provided. Whereas, my lord, 4.4 says, if a person belonging to any of the categories mentioned in subsection 2 gets selected on the basis of merit in an open competition with general candidates, he shall not be adjusted against the vacancies reserved for such category under subsection 2. This is what the Adhiniyam says. My lord, in a utopian world, I would say we could have done with better rules. Right now, there is no such rule here. What all there is 55 as clarified by 29, which says follow 22, 22A. I have shown your lordships what 22(2)(a)(1) says. It says these are the reservations, you have to follow this. This is what 55 said, 29 also says. In fact, 29 goes a bit further. It says if after you go through 22, if you find that there are certain candidates, certain categories which have not been up to the mark, then you go further down and pick them up. And I have shown your lordships the table by which it is very clear that in a group of 31,000 people who got selected, 28,000 are from reserved category. It is very clear, my lord, 29 is inuring to their benefit only. Now kindly see 22A also at page 45. This is specifically with respect to women. Notwithstanding anything contained in these rules or special rules or ad hoc rules, in the matter of direct recruitment to posts for which women are better suited than men, preference shall be given to women, provided that such absolute preference to women shall not result in total exclusion of men in any category of posts. Then, in the matter of direct recruitment to posts for which women and men are equally suited, there should be reservation to women to an extent of 33 1/3 of the posts in each category of open competition. Socially and educationally backward classes Group A, socially educationally backward classes B, C, D, E, scheduled castes, scheduled tribes, and persons with disabilities and ex-servicemen quota. Then 3. In the matter of direct recruitment to posts which are reserved exclusively for being filled by women, they shall be filled by women only. Then Millet 4 deals with promotion and appointment by transfer. Therefore, Millet, my respectful submission before your lordships is that both 55 and 29, they speak about 22, 22A. It is nowhere near to a provision like 4(4) of the Adhiniyam 1994. Therefore, Millet, that judgment is not applicable to the facts of our case. So kindly see the comparative table which the Divisional Bench drew with respect to amendment. Now let us see whether any at page 35, Milord, paragraph 33, where constitutionality of rule 4(3)(d) Roman 3 of the examination rules, Milord, is extracted.
It's in bold letters.
Beg your lordship's
It is
pardon.
in bold letters.
Yes, Milord, in bold letters.
Page
Yes.
37.
Page 35, para 33, Milord.
But the offending portion is reproduced at page 37. In the middle column.
Yes, in bold. Yes, I am blessed.
It
Yes,
is in bold.
yes. I am carrying coal to Newcastle, Milord, but I have to, Milord, show your lordships. This is, it begins at, I am obliged, Milord.
It was highlighted in fact.
Yes, yes. This is what is highlighted, but above adjustment will be only at the time of final selection and not at the time of preliminary or main examination. This, Milord, in my respectful submission, does not exist in our matter at all. Now kindly see how the Divisional Bench saw the main rule and the amendments at page 38 after the table extraction. A comparative reading. My lord, spot it, my lord.
Paragraph.
Page 38, just above para 34, after the table. A comparative reading of main rule and two subsequent amendments above makes it clear that as per main unamended rule, the meritorious reserved category candidate was entitled to compete with UR category candidates and get his position in open UR category. By impugned amendment dated 17/2/2020, this right was taken away by confining the benefit at the time of final selection only. This is not there in our case. By subsequent amendment dated 2012/2021, the earlier position prevailing at the time of unamended rules was restored. Thus, the impugned amendment became a hurdle for the meritorious reserved candidates to be treated as UR open category candidate. Then your lordship have said about Indrashani, which we have no merit quarrel. That is stated in para 44 at page 42. Para 44, second paragraph, my lord. We are of the considered view, Lordships got it, my lord, that the principles laid down by the Supreme Court in Indrashoni can be translated into reality only when reserved category candidates secure equal or more marks with unreserved category candidate in given birth in UR category in all stages of selection, including preliminary and the main examination. Any other interpretation would defeat the purpose and the constitutional scheme flowing from 14 and 16 of the Constitution of India. There is no justifiable reason for depriving a meritorious reserved category candidate who has competed with UR category candidate and secured same or more marks than from being treated as UR candidate. Then at the end of that paragraph, my lord, your lordship said we accordingly at page 43, just above para 45, we accordingly declare rule 43D3, my lord, of the amended rules as unconstitutional. Now, my lord, the correctness of this was subsequently doubted by a coordinate bench of the Madhya Pradesh High Court.
Is it a bench headed by Honorable Justice Sheel Nagu? Is it a bench headed by Honorable Justice Sheel Nagu?
My lord, I have that. There is another judgment, my lord, which considered both these judgments. This judgment is on 21st November 24 by Chief Justice Kait and Justice Vivek Jain. Another division bench order.
The recent one.
This is the latest one. I'll just pass on. जो कोई भी है. My lord, this is with respect to recruitment in the judiciary of Madhya Pradesh. The first page, my lord, the prayer is extracted. Kindly go to page 3, my lord. A coordinate bench of this court in Kishore Chaudhary, para 45 is extracted. Later, another coordinate bench of this court in Pushpendra Kumar Patel and others versus State of MP and others in so and so taking contrary view, held as order.
Just a minute.
Yes.
This subsequent judgment, do you have this Pushpendra Patel with you?
I'll pass on.
This must be by a bench headed by Honorable Justice Sheel Nagu.
Yes, I'll just pass on. Right now I don't have it. I'll ask my colleague to take.
Then how the recent bench held?
Yes, the recent bench, Jabalpur bench. Kindly go to para 8. It is pertinent to mention here. I am reading page 3, para 8, my lord.
Yes.
It is pertinent to mention here that recently the Honorable Supreme Court of India, in the case of Deependra Yadav and others versus State of Madhya Pradesh, then my lord, para 30 onwards is extracted. Kindly come to page 5, paragraph 9.
Yes.
The Honorable Supreme Court in Deependra Yadav has approved the legality and validity of extending the benefit of migration to meritorious reserved category candidates in unreserved category in all stages of selection as held by coordinate bench of this court in Kishore Chaudhary. Therefore, my lord, I can say that it is again quoted approvingly. Then in view of the above, we direct that henceforth in all future recruitment exams conducted by examination cell of High Court of Madhya Pradesh, benefit of migration shall be extended to meritorious reserved category candidates in unreserved category in all the stages of selection process. It is however clarified that ongoing recruitment examination conducted by the examination cell wherein examination, preliminary or mains as the case may be, has already been conducted shall not be affected by this order. My lord, this is brought to your lordship's notice only to show the development, my lord, in that aspect. Though, my lord, we are nowhere concerned with all those three, my lord, division bench judgments. I'll give the complete judgment of the second coordinate bench, my lord. Therefore, my lord, as far as Kishore Chaudhary is concerned, because of the fact that the rules, the examination rules, my lord, or the adhiniyam, none of them, my lord, are anywhere connected to either 29 or Rule 22. Those judgments, my lord, in my respectful submission are not applicable. Nextly, my lord, kindly go to Daria, my lord, was extensively quoted, my lord, in the affidavits of most of the parties. Rajesh Kumar Daria, before I show Deependra Yadav, this is 2007, compilation, my lord, page 83. Judgment compilation, page 83. Only one para, my lord, I would like to invite your lordship's kind attention. Page 87 of the compilation, my lord. Paragraph 5.
Yes.
Rule 9(3) of the Rajasthan Judicial Service Rules 1995, which is relevant, reads as follows. 9(3) Reservation for women candidates shall be 20% category wise in the direct recruitment. In the event of non-availability of eligible and suitable women candidates in a particular year, the vacancies so reserved for them shall be filled in accordance with the normal procedure, and such vacancies shall not be carried forward to the subsequent year. And the reservation treated as horizontal reservation, that is, the reservation for women candidates shall be adjusted proportionately in the respective category to which the women candidate belongs. My lord, this is the rule which fell for consideration before the Supreme Court in Daria's case. Now, we have no quarrel with this. Even in our state, my lord, the very same thing is being implemented. Pursuant to this, our rules were amended. Now, kindly see where is the mention with respect to physically handicapped, my lord. Para 9 at page 790, the running page 88, my lord. Paragraph 9. The second relates to the difference between the nature of vertical reservation and horizontal reservation. Social reservations in favor of SC, ST and OBC under Article 16(4) are vertical reservations. Special reservations in favor of physically handicapped women, etc. under Article 16(1) or 15(3) are horizontal reservations. Except this sentence, Daria does not in anywhere deal with the question of reservation for physically handicapped persons. Except this sentence in paragraph 9. But this is nothing but obiter. This has no binding precedents whatsoever, my lord, with respect to the issue at hand. Because the Supreme Court also was concerned with Rule 9, which deals with reservation for women candidates. Now may I invite your lordship's kind attention to Deependra Yadav, my lord, which is the sheet anchor of the petitioner's argument. It commences at page 45. May I invite your lordship's kind attention to page 48, paragraph 1.
Yes.
Leave granted only in SLPC number 5817 of 2023. Lordship got that point? Kindly see what this SLP is about. That is at paragraph 11, page 53.
Yes.
While so, some candidates filed WP through 23828 of 22 before the High Court of Madhya Pradesh at Jabalpur, assailing the decision of the MPPSC to cancel the result of the main examination held earlier on the ground that they would be required to reappear for the said examination despite clearing it in the first instance. The petitioners in SLP number 5817 of 23, from which this appeal arises, intervened in the said petition and they were also heard. This writ petition was filed on 13/10/2022. Therefore, my lord, the substantive writ petition is 23828 of 22, my lord, which is again with respect to assailing the cancellation of the examination. My lord, the situation does not arise here. There is no cancellation whatsoever. Now, my lord, kindly see, your lordship knows, my lord, the history, since, my lord, your lordship have extensively dealt with it. in Kishore Chaudhary, my lord, the Supreme Court had extracted the history at page 48, paragraph 3, line about 5 from bottom. Exactly what your lordship, my lord, said at paragraph 2, my lord, somewhat similar words. The preliminary examination took place on 12/1/2020. The total number of candidates who registered for the preliminary examination stood at 3,64,877, but only 3,18,130 of them actually appeared for the examination. At that stage, on 17/2/2020, Rule 4 of the Rules of 2015 was amended by State of Madhya Pradesh. Then, my lord, Rule 4 is extracted. The effect of Rule 4, my lord, is extracted, is stated in para 5, page 50. Paragraph 5, my lord, page 50.
Yes.
In effect, the amended Rule 4 of the Rules of 2015 provided that adjustment and segregation of meritorious reservation category candidates with meritorious unreserved category candidates would be only at the time of final selection and not at the time of preliminary main examination. 6, my lord. Surprisingly, the amended Rule 4 was applied to the ongoing recruitment process relating to notified 571 vacant posts. The result of the preliminary examination conducted on 12/1/2020 was declared on 21/12/2020, applying the amended Rule 4. Thus, there was no segregation of meritorious reservation category candidates with those from unreserved category candidates, and they were shown in their respective reservation categories only. The number of candidates who cleared the preliminary examination on this basis was 10,767. Then, my lord, Kishore Chaudhary is quoted at paragraph 9, page 52. Notwithstanding this amendment, the result of the main examination held between 21/3/21 and 26/3/21 was declared by the MPPC on 31/12/21, and the number of candidates who provisionally qualified for interviews was 1,918. However, by judgment dated 7/4/22, a division bench of the High Court of Madhya Pradesh at Jabalpur partly allowed the pending writ petitions, namely WP so-and-so and batch titled Kishore Chaudhary versus State of Madhya Pradesh and another. Challenge in this batch of cases was not only to the validity of amended Rule 4(3)(d)(3) of the Rules of 2015, but also Section 4(4) of the Adhiniyam. Then, my lord, 4(4) is extracted. My lord, the order in WP 23828 of 22 before the Division Bench of the Madhya Pradesh High Court is extracted at para 14, page 54. This is what, my lord, the learned judge did. The learned judge observed that if the result of the main examination was cancelled, a premium would be given to the candidates from the 4th category by reviving their candidature. Before that, my lord, in para 13, the type of candidates that emerged in view of the amendment to the rule and conduct of 3 main examination is extracted by the Supreme Court. Then, my lord, though not relevant, my lord, I am just by reviving their candidature, though they had failed to qualify in the first instance, and the right would be taken away from candidates who had already cleared the main examination and qualified for the interview. The learned judge opined that this would cause serious prejudice and grave injustice to candidates who were declared eligible and had qualified in the shortlisting process, and that holding the entire main examination afresh would not only result in incurring huge costs but also cause grave injustice to a large number of candidates who had already cleared the main examination and were shortlisted for the interview without any fault on their part. Holding so, the learned judge invalidated the decision taken by the MPPC on 10/10/2022 proposing to hold a fresh main examination by cancelling the earlier one, and directed the MPPSC to hold a special main examination as was done by it earlier on several occasions for the new eligible reservation category candidates as per the redrawn preliminary examination result. The learned judge directed that on the basis of the results of these 2 main examinations, a fresh list of selected candidates should be prepared in terms of the rules of 2015 for the interview by merging and normalizing the 2 lists as per the process adopted by the MPPSC on previous occasions. This exercise was directed to be completed within 6 months. My lord, this is the list, my lord, from which the SLP arose before the Supreme Court in Deependra Yadav. paragraph 14. But my respectful submission is, my lord, this situation is not there before your lordships at all. The facts are completely different. No question of any 3 mere examinations be conducted, 3 different lists, cancellation of one of them, though the petitioner tried their best at the interrogatory stage to ensure that the main is not conducted. Unsuccessfully though. Then, my lord, in this situation, now kindly see the observations which the petitioner seek to rely, paragraph 30 at page 59. It is far, far, far more complicated, my lord, what happened in Madhya Pradesh. My lord, and it was also sought to be justified and successfully though, my lord, I could not understand how the normalization could take place and how the reserved category candidates would be adjusted against which post, my lord. That situation fortunately doesn't exist here. Para 30, page 59. We may also note that Rule 4.3d Roman 3 of the Rules of 2015 patently harmed the interest of the reservation category candidates, as even meritorious candidates from such categories who had not availed any reservation benefit relaxation were to be treated as belonging to those reservation categories, and they were not to be segregated with meritorious unreserved category candidates at the preliminary examination result stage. As a result, they continued to occupy the reservation category slots which would otherwise gone to de-reserving reservation category candidates lower down in the merit list of that category, had they been included with the meritorious reserved unreserved category candidates on the strength of their marks. Then, my lord, the operative portion, page 61, para 34, second paragraph. The civil appeal arising out of SLP 5817 is therefore bereft of merit and is accordingly dismissed. If your lordship would see the observations of the Supreme Court from para 30 onwards, though we have no quarrel, we are not saying we are not following that. We are not saying we are depriving at all. As my lord shown, the data itself shows, my lord, the question of deprivation doesn't arise. 28,000 out of 31,000, it is very clear, my lord, that the reservation category candidates have been taken care of amply. And all of them, my lord, are eligible to compete, my lord, in mains against open category only. There is no, my lord, quarrel with respect to that also. Para 14, your lordship have seen what is the subject matter in the writ petition and how the learned judge dealt with it and what was the SLP before the Supreme Court. Therefore, my lord, the facts of the case, Kishore Chaudhary and my lord Deependra Yadav, though not directly in my lord, challenge before Supreme Court, they both arise out of the same fact situation, and that fact situation is not existing, my lord, in the present case. In fact, GO 29 is brought in to avoid that situation. That is what Balaji Badawat paragraph 43 says, which I have invited my lord earlier. I don't want to repeat on that, my lord. So, my lord, my friend Mr. Sudhir, my lord, this answers my lord, submissions with respect to Mr. Aditya Sondhi's contentions and Mr. Madan Mohan Rao's contentions with respect to 55 and 29. And, my lord, especially Mr. Sondhi's arguments that the Public Service Commission should not have followed 29, we should have gone back before Justice Madhavi Devi. All that, my lord, is water under bridge. I have already answered.
Reconduct.
Beg your lordship's pardon.
The emphasis on the word reconduct the exam.
Yes, reconduct, yes, on the aspect of reconduct of examination. Now, my lord, coming to the question of my lord, my friend Sudhir's submission that this whole thing is done, that is the cancellation as well as the re-notification. Though, my lord, I couldn't find the submission in the pleadings, which, my lord, he has filed. He is very elaborate, my lord, in his pleadings as well as prayer. That due to change in the political scenario, my lord, this has come about. Well, I fail to understand, my lord, what is the basis for this submission, firstly. Now, my lord, to give it back to him, not my lord, necessarily the same words, this appears, entire thing appears to be, my lord, politically motivated. Your lordship may see. I have shown the list where participants who have qualified the prelims are before this court, without saying, my lord, what is their concern. And in fact, Mr. Sudhir's case, my lord, they filed after the mains was conducted. They wrote the mains examination, thereafter they filed the writ petition.
That is WP number?
WP number 32482 of 24. 32482 of 24. Three of them, my lord, did not qualify.
19th of November 24.
Yes.
Both type of them.
I am not denying. Three did not qualify. Two qualified. I have shown the statement.
It is filed on 19th November.
Correct.
Yes,
Not
yes.
on that. My friend is saying all of them have.
No, I didn't say all. I'm sorry. Statement ichchan kada.
I'm
Statement.
only trying to say about there are two types of people.
Yes.
Category A, category B. Which I'll explain.
Yeah, when I showed Ashok Kumar, your lordship, my lord, posed a direct question to me. Does that situation arise here? The challenge after participation principle can you put against a person who is successful? Because, my lord, normally what they say, challenge after participation, if you are unsuccessful, you cannot because you know the process even before you commenced. Then I said possibly to get over that. My lord, people who are passed are also included. But, my lord, posing a question to myself, how do you deal with those people who are failed? I have given.
The question is hypothetical question, but suppose it is few at the behest of few petitioners who were successful, petitions are maintainable, and suppose they succeed, everybody will get benefit.
But
Because here the GO is under challenge.
Yes.
In case at the behest of successful candidates, we agree, suppose. So hypothetical question.
Yes,
we
yes,
have not made
yes,
up
yes,
our
yes,
mind.
yes.
Then GO will go for everybody.
But that would
We
mean.
will not say that it is quashed for successful candidate and it is
No,
applicable
that
for
is
unsuccessful.
true. That is true. But that would mean, my lord, your lordship would have to. I am not saying hypothetically again.
In other words, there are few persons, those who have locus to challenge.
Or my lord, contrarily, let me put it like this, my lord. Again, hypothetically, my lord, I am saying, your lordship would have to negative our contention that people who participated and failed cannot challenge. In case if your lordship would have to agree with those people who succeed, my lord, in spite of the fact that they participated, your lordship would have to negative our contention that those who have did not succeed, my lord.
We'll deal appropriately.
No, I know that, my lord. Since your lordship has said hypothetically, I am also saying hypothetically. I have no doubts with respect to that, my lord, that your lordship would deal with all this. I have no doubts whatsoever. Since your lordship said hypothetically, I am only saying this because I said to get over Ashok Kumar, my lord, people who are successful are brought on, is what I submitted before your lordships. And for that, my lord, it is for them to explain to your lordships what is the grievance that they have. I can understand a person who failed, my lord, who cannot get employment. Person who passed is also before your lordships, my lord. That is where the political scenario aspect would come into play. Very clearly. Lord, I'll just pass on, my lord, this judgment of the division bench. Your lordship just now requested. Though I must say I didn't read the whole judgment, my lord.
This is,
Justice Sheel Nagu and Justice Virendra Singh.
I am aware of that.
Your lordship just now asked, my lord, sir.
Because in the recent judgment by Justice
Suresh K.
Chief Justice,
Yes, K.
It has been said that Kishore Chaudhary will be followed henceforth.
Yes.
Not
yes.
this one.
Yes.
I remember because it's from my parent High Court.
Yes, my lord.
I know the-
No, since your lordship asked me 5 minutes ago, I requested my colleague to get copies. So that
But after that, when you read that judgment of Honorable Justice Kat,
of Chief Justice
the
K.
relevant portion of this judgment is also
Extracted
reproduced.
there, yes.
So I could lay my hands then and there only.
Yes.
You may continue tomorrow. Mr.
Very well, my lord. I have concluded, my lord. My friend Rahul will.
Tomorrow, Mr.
Yes.
Rahul. Tomorrow. Parties through their counsel. Hearing in this part heard batch commenced. Shri Rajshekar, learned counsel for TPPSC, concluded his arguments. Because of paucity of time, list tomorrow as a part heard matter, immediately after motion.
My Lord, my item number 395 will post it tomorrow.
395 post tomorrow. This matter may consume whole time. So take your chance. If time
Yes,
permits,
my
we'll
Lord.
hear you.
My Lord, it took for time for this one. Mine also the part heard matter, my Lord.
Take chance, because without concluding this, we'll not be able to switch over to other
After
matters.
this, I will.
Yes.